As he seeks to smash and grab $230 million, Donald Trump's reckless campaign to wreck the rule of law with his prosecutions is today wobbling a bit like a Jenga tower that got a little too tall. Today, in two jurisdictions in the Eastern District of Virginia and in New Jersey, Trump's handpicked prosecutors, both with zero experience as prosecutors, but totally down with going after Trump's critics, regardless of the facts in the cases, are both facing challenges to their appointments, to the legality of them. Politico is reporting that judges appeared skeptical of Alina Habba's appointment to be the acting U.S. attorney in New Jersey. And whatever happens in Alina Habba's case could have an impact on a challenge to the appointment of Lindsay Halligan over in the Eastern District of Virginia. Former director of the FBI, Jim Comey, has filed a motion claiming that Halligan's appointment was unlawful since U.S. attorneys are only allowed to serve without Senate confirmation for 120 days, and the previous U.S. attorney in the job had already served a full 120-day stint. That would be Eric Siebert, who we have covered here. He was fired for refusing to bring the cases against Jim Comey and New York Attorney General Tish James because there wasn't enough evidence. If the court rules in Comey's favor and finds that Halligan was improperly appointed, Comey's case could be tossed out, as could the case against Tish James. These, of course, are two pillars of Trump's retribution campaign that would collapse because the Trump administration hastily put inexperienced loyalists in the positions of U.S. attorneys without any regard for the law. But the cases against Comey and James might be in danger even before any court rules on Halligan's appointment. A reporter named Anna Bauer from the news outlet Lawfare is reporting that Halligan started a bizarre 33-hour text exchange with her on Signal. Bauer writes this, quote, "She initiated a conversation with me, a reporter she barely knew, to discuss an ongoing prosecution that she is personally handling. She mostly criticized my reporting, or more precisely, my summary of someone else's reporting, but several of her messages contained language that touched on grand jury matters, even as she insisted that she could not reveal such information, which is protected from disclosure by prosecutors under federal law. Not once during their conversation did Lindsay Halligan say that their conversation was off the record." Here's what happened when Bauer, the journalist, reached out for comment from the Justice Department. Quote, "Halligan texted me, quote, 'By the way, everything I ever sent you is off the record. You're not a journalist, so it's weird saying that, but just letting you know.' I responded, 'I'm sorry, but that is not how this works. You don't get to say that in retrospect.' Halligan was unpersuaded. 'Yeah, I do, off record. I'm really sorry. I would have been happy to speak with you on an off-the-record basis had you asked,' I said, 'but you didn't ask. And I still haven't agreed to speak with you on that basis. Do you have any further comment for the story?' To my surprise, Halligan kept going. Quote, 'It's obvious the whole combo's off record. There's disappearing messages, and it's on Signal. What's your story? You never told me about a story.' I didn't respond. It was time to publish my story. I'll text it to her." We're back with Andrew and Mike. I don't know whether to deal with the legal issues or the stupidity first, but the stupidity is just unbelievable here. Now, you could, I guess, legitimately not understand that texting a journalist, not about her own reporting, but about her summaries about someone else's reporting, is something if you don't want to see in print, you should ask the conditions. But to be sharing grand jury information, to me, seems like something that even in this bizarre Earth 2 world could get Lindsay Halligan called into the principal's office, Andrew?
So to be fair, she does say in her text, I can't go further because I can't go into grand jury information. But on the other hand, she does confirm information by saying essentially, yes, that happened in the grand jury, but I can't go further. So just because the New York Times is reporting something, which is, Anna Bauer was summarizing that, it hasn't been confirmed by the government one way or the other. So the government is not supposed to be saying that there, that did or did not happen in the grand jury. But I view this as even more nefarious. I mean, yes, there is stupidity here and clumsiness, but just so it's clear, Anna Bauer, who writes for Lawfare and is a wonderful, wonderful reporter, I read her material all the time because she's so good, so smart. She was pointing out what appeared to be serious legal flaws in the Letitia James case. And what was happening was she got a call from Lindsay Halligan saying, basically, you need to change all of that. You've got it wrong. And Anna Bauer correctly said, well, tell me what I got wrong. I don't want to report something wrong. What's wrong with it? And Lindsay Halligan would say, just essentially change it. You're a bad reporter, but never said what was wrong with it. So, of course, Anna Bauer wasn't going to change it. But there was this effort to basically get the press to be positive about something and sort of have a a threat. Remember, this is Lindsay Halligan, who was brought to what appear to be, in my view, sort of baseless lawsuits, calling a reporter saying, change it, you've got it wrong, but never revealing what exactly is wrong with it.
Joining us now, MSNBC Justice and Intelligence correspondent Ken Delaney and MSNBC legal correspondent Lisa Rubin, former Deputy Assistant Attorney General Tom Dupree, and Lawfare's legal fellow and courts correspondent Anna Bauer. Anna had an interesting few days. We're going to get to that in just a moment. Ken, let me start with you. This legal filing, a lot of words, a lot of different ways to say one thing. This case is political retribution, and that is illegal under the law.
Yeah, that's right, Katie. And in fact, what they're saying is Exhibit A, of course, is Donald Trump's Truth Social post, which may or may not have been intended as a direct message to his attorney general, where he called Comey a bad guy and said that he should be prosecuted. And it's just really hard to argue with that. I mean, it's out there for the world to see. But Comey does, and his lawyers do, include a raft of other evidence in this motion, including the fact that the Justice Department fired his daughter, who is a prosecutor in the Southern District of New York, without cause. But what's really interesting to me is that after amassing this set of evidence in this lengthy motion, essentially Comey's lawyers make this pitch to the judge. Look, if you don't want to rule in our favor based on this information, let us have discovery and we'll have an evidentiary hearing. And what that means is they will want to get all the communications between the White House and the Justice Department about the Comey case and all the machinations about the career prosecutors who didn't want to move this case forward, and who in the White House was pushing who in the Justice Department to bring the case forward. And all that would buttress a case that this was a vindictive and selective prosecution. If they get that, this is going to take a long time, first of all, for the DOJ and the White House to produce. There'll be battles over which documents get produced. But we will learn a lot more than we know now about exactly how this case came to be, and that will be fascinating.
That right there is really interesting, Tom.
Well, it sure is. And look, to state the obvious, maybe it would be exceedingly unusual for a district judge to allow that kind of discovery into the behind the scenes machinations and the discussions among prosecutors and the president. That said, this is an extraordinary case. My sense is that this motion, I don't think, is likely to succeed in getting this indictment thrown out, at least at this time. I'm not faulting the defense for bringing it. If I were in their shoes, I would litigate this case aggressively. I would take that shot. But the standards for getting a case dismissed on grounds of vindictive or selective prosecution are so high.
Well,
so many motions are filed and none
succeed. If this doesn't meet it, what does?
Well, maybe nothing does. But the fact is that judges are extremely reluctant, to say the least, to throw a case out on these grounds. I think they have much better chance of taking the shot at the appointment process through which Lindsay Halligan got this job. That also presumably would lead to dismissal of the indictment and is a far less legally difficult, complex road for the judge to travel if he wants to throw this case out.
I can feel you wanting to chime in.
I was going to say, I agree with Tom that is the better of the two legal arguments, but I just want to underscore from their brief how unusual this particular case is, because I can't think of any other circumstance in which a criminal defendant comes forward and says, these are the things the president of the United States has said about me. So I'm going to read from the brief. Among other things, President Trump has publicly called, and these are all quotes, Mr. Comey a corrupt piece of garbage, a disgraced liar and leaker, a weasel, a weak and untruthful slimeball, and very sick or very dumb. Those statements reveal a deep personal animus toward a perceived political enemy. And the standard for vindictive vindictive prosecution, which is a separate legal concept than selective prosecution, is about a particular person's animus toward the defendant. It's hard for me to conceive of a case with more animus than this one.
Yeah, you keep correcting me because I keep mislabeling it as a selective prosecation. And you lawyer me and you say, you got to get your terms right. It's vindictive. I guess I'm just
they're doing both.
I'm stuck on this, though. Why even have it if there's never going to be a case that amounts to it? If you have the president of the United States in a direct message that was public or a public message, whatever, saying, I want these people prosecuted, how does that not meet the standard? And if it doesn't, what's the point of having it?
Well, I mean, I think the point of having it is to ensure to the greatest extent possible that justice is not corrupted by personal vendettas and vindictive motives and the like.
Yeah.
But look, the thing here is that the government is going to be able to credibly say, look, yes, absolutely, Trump hates Jim Comey. I mean, you could have gone on for 10 minutes with those sorts of things that he said about him. No question about it. But I think they would say, look, there is some evidence here from the government's perspective that would support a conviction. And so let the process play out rather than throw this out. If there was no evidence supporting it whatsoever, then maybe you would have a vindictive prosecution argument. But I think what they would say here is, look, yeah, it is vindictive, it's retributive, but there is some evidence supporting it, so that's why it should go to a jury. That's the defense.
Anna, let's talk about...
This is really bad news. This stuff surrounding the grand jury and Halligan, which is Trump's gal, and Letitia James case. This is bad jury news stuff for Trump and his team. And how it will affect the direct case is complicated, but I do think it could have bad jury news there as well. Because on the one hand, it's important to note that these sorts of scandals, if the trials actually do happen, would likely be excluded from jury deliberations. Meaning, I do think there's a real chance that with the Comey and Letitia James case in particular, those two in particular, that the cases could be easily thrown out before they begin, based on malicious prosecution. That the prosecution is clearly being done for political and personal reasons, and that there's not enough evidence to bring a good faith case forward. And the judge could make that argument and just have them dismissed on the outset, right? But even if that doesn't happen, and you go to a trial, you won't be able to bring in this evidence. The defense won't be able to say, here's this stuff about the texts that'll likely be excluded because it might prejudice the jury against the case or whatnot. But let's say it isn't, that's going to make them look bad. But you also have to think, if this is how they conduct themselves, if this is how Trump's prosecution conducts themselves, just leaking stuff all willy-nilly and then them saying at the end of the day, actually, that's off the record, which you can't do. You can't leak something and then say it's off the record. I'm sorry, that's not how it works, right? Especially when you're in the DOJ. Then what other mistakes is she going to make that gives the jury pause in the actual trial if it gets to that point? Right? This is a walking, talking time bomb. And look, the judge may say that this stuff is admissible, or this stuff that was leaked could be used by the Comey team and the Letitia James team or what have you in their trial, and basically use that information to build their case and find new angles to approach the trial that makes their likelihood of success and therefore Trump defeat at the hands of a jury that much higher. So guys, the jury, they're about this jury-related news is bad for Trump. It's bad for Halligan. It's bad for everyone on the Republican side, except for Comey, who is a Republican. But it's good for justice that we got to see this mess.